welcome. Thank you for joining me for webinar number 4 in this series of webinars sponsored by Stewart Title. A massive thank you to Stewart Title once again for sponsoring this event. Please do talk to Freddie, Robert, Ted and the team at Stewart Title about your training needs for compliance issues relating to defective title and about any requirements that you may have concerning defective title insurance. I'm fortunate enough to work with Robert, Freddie, Ted, Stephen and everyone else at Stewart Title, and they're all there with their expertise willing to share and assist you in connection with defective title insurance. They have an online solutions policy or system and process for online policies, which is brilliant, and they also have underwriters and expertise to be able to issue or consider bespoke policies. So a massive thank you again to Stewart Title, and a massive thank you for you for turning up this morning and attending to talk about issues relating to completion. As usual, we are recording today's event. The recording will be made available to you. As also usual, I am happy to take questions as and when necessary. The best way of doing that is for you to put questions in either the question box or the chat box, which you can see hopefully on the dashboard to the right hand side of your screen. So hopefully you're sitting comfortably, hopefully you can hear me. Let's have a look at what we do when we're preparing for completion. Let's have a look at completion itself, and then let's talk about what we can do in circumstances where things go wrong. So an awful lot of things to talk about. The first thing is, of course, and the important thing to understand and appreciate is the fact that we need to be aware of our duties and obligations relating to completion. And from the seller's perspective, I'm obliged to produce a good and marketable title. And from a buyer's perspective, I'm expecting to receive a good and marketable title unless the contract makes provision to the contrary. It's therefore important when we're dealing with registered land that we review the official copies of the register. We'll have already reviewed them when we've performed our due diligence exercise when we're acting for the buyer, and we'll have done the same thing when acting for the seller and producing the contract bundle. But in readiness for completion, let's just have another look at the title and see if there are any issues there that could cause us problems. If there are documents referred to in the official copies of the register and we haven't already produced them for the buyer, we're contractually obliged to do so. Hopefully, where there are documents that are referred to in the official copies of the register that we can't produce them, we'll have referred to that issue and that problem as an encumbrance in the contract, so there'll be no expectation for us to produce it. When acting for the seller, we need to be alive to the fact that when our buyer does their land registry search, there could be new entries in the land register that require addressing, and there could be notices or restrictions on the title that either we have considered and have dealt with in the TA13 form, or which are new issues and new problems that we're going to have to address before we properly complete. So if we're acting for the seller, let's have a look at our title. Let's look to see if there are notices in the charges register that refer to interest in land that are going to terminate at completion. Let's look at our form TA13 and check whether undertakings are to be provided relating to those interest in land protected by notices, or whether the interest in land is being extinguished, and make sure that we're comfortable with the undertakings that we're being asked to provide, or the steps and measures that we're expected to take to facilitate removal of notices. The next thing to talk about are the restrictions on the title. And again, I've mentioned this throughout this course. It's important to check whether there are any restrictions on the title that we're selling, and to check whether we feel it possible for the buyer to be able to comply with those restrictions in order to register their title after completion. The land registry have bombarded me with problems that they're currently encountering, and one of the major issues that they've got, one of the major issues that they're requiring me to explain to the profession, is the problem associated with an inability to comply with restrictions. Imperative that we do an audit of the title on behalf of a seller. If there are restrictions on the title, is the buyer going to be able to comply with them? During the course of the transaction, have we resolved or remedied the position relating to restrictions? If we haven't, now's our last chance. If we're completing this Friday and we're undertaking a file review and we've identified a restriction, or the other side solicitors, the buyer's solicitors have said they have a problem with regard to a restriction, It's probably too late now for us to apply to disapply or cancel or modify the restriction before completion takes place. It may well be that the buyer is going to refuse to complete if it's aware that there is a restriction that can't be complied with. Alternatively, the buyer will complete and then we'll find out there's a problem with the restriction that will require some form of activity, probably from the seller's solicitor after completion, and will certainly involve the buyer's solicitor in undertaking work to try and ensure that either the restriction can be complied with or that the restriction is disapplied. When dealing with unregistered land, check for the position with regard to the buyer's land charges search, where that search is undertaken, and again throws up land charges that are recorded against the name of the seller. We're going to have to deal with them. So doing an audit just to see if everything is in order is fine. An awareness of anything that could be thrown at us courtesy of the buyer's land registry search or land charges search undertaken just before completion might give us an opportunity to address those issues and even potentially resolve them before we complete. As I've said throughout this course, the important thing in the conveyancing process is to give yourself time to spot problems or issues before they arise and to deal with them. I don't want, on the day of completion, our imaginary completion day being Friday, having the morning from hell, having to deal with issues in order to get my sale over the line or my purchase over the line. One, it's not good from a heart perspective, stress perspective for you. Two, it will lead to dissatisfied clients where there are problems and issues that are just encountered or just spotted on the day of completion. And three, there may be problems that are incapable of resolution on the day of completion. It's going to involve a delay in completion. All of those matters are going to increase the amount of time and energy you're going to be spending on the file. And my guess is you're not going to be able to recover all the additional time, energy, and costs that result. So it's all well and good encountering a problem on completion. It's all well and good resolving that problem on the day of completion. You're not going to be paid any extra for doing it. Spotting the problem early on and resolving it is good. Spotting the problem and explaining to the client the cost implication of resolution is satisfactory from a profitability perspective, but making sure that problems and issues are dealt with in a timely manner so that we can have a nice smooth completion, obviously the best course of action and obviously good practice. So I mentioned looking at notices on a title, and remember, when you're looking at a notice recorded on a registered title, the notice doesn't validate or legitimize the interest in land. It is simply a statement that someone contends that they have the benefit of an interest in land. Therefore, from a seller's perspective and a buyer's perspective, is there in fact a valid interest in land that can be protected by the notice? If there isn't, then we should be thinking about cancellation or challenging the notice and getting it off the title. Now, in an ideal world, this should have been done weeks ago, months ago, when we audited the title, when we're acting for the seller, or when the buyer considers the title. But again, if there's a problematical notice on the title that's going to need addressing before we complete on Friday, first thing, basics, is this notice actually protecting an interest in land? We can look at the documentation that was submitted in support of the application for that purpose. We might think about challenging the notice or seeking cancellation of the notice. And remember what we said the other week, Section 77 of the Land Registration Act 2002, if someone lodges a notice on a registered title without reasonable cause and you sustain loss as a consequence, you can recover that loss. So in the context of what we're talking about today, this would mean that if we couldn't complete and we're being charged interest as a consequence, that interest could be recoverable from whoever has lodged the notice on our registered title, provided, of course, they've done so without reasonable cause. Remember, agreed notices are far harder to remove. They're going to have to be cancelled, in essence. They can't be challenged. And remember, an agreed notice doesn't need the agreement of the registered proprietor, but will need some form of documentary evidence in those circumstances to establish the validity of the claim. So again, if we're not sure about whether a notice, an agreed notice, is in fact protecting an interest in land, have a look at the documents that have been submitted in support. With regard to unilateral notices, have a look at the UN one. And again, ask yourself, is this protecting a valid interest in land? Is there any doubt about the validity of the interest in land? If there is, can it be challenged? And again, last resort today, if we're completing on Friday, to see what we're going to think. If there is a unilateral notice that's just been lodged on the title, or indeed an agreed notice lodged on the title, relating to an interest in land that we're not aware of, that is going to be binding on a buyer client, we can refuse to complete until the matter is resolved to our satisfaction. Watch out, as we've said in the past, about persons in occupation of the property. Ideally, if I'm really concerned about someone that's in occupation of the property, I would like them to vacate before we exchange, and I would like proof of vacation. I'm particularly jumpy about homes rights notices, again, because as I've mentioned in the past, often the occupational issues can be used as a carrot or a stick in connection with other disputes, maintenance, children, etc. And therefore, we might have had a very cooperative spouse or civil partner who just before completion digs their heels in and says, I'm not moving out. Again, we've got to be careful. A homes rights notice should be utilized to protect their interests, but it's their occupation in essence that generates the problem. So we need to have them out, or alternatively, we need to check when we're acting for a buyer that we've still got that cooperation and we're comfortable that the person in occupation of the property, other than one of the contractual parties, is going to move as requested. Again, if in doubt, take a step back. I'm not going to complete unless I am satisfied that Mr. X or Miss Y is vacating the property on the day of completion. I mentioned land registry restrictions, and again here, these issues with regard to restrictions are often overlooked. I've got data from the land registry that confirms the point. And the issue here is that if there is a restriction on the title, can it be complied with? Well, first of all, does it protect an interest in land? Same principle as a notice. If it does protect an interest in land, then what we've got to ask ourselves is, can the restriction be complied with? Again, a check should have been undertaken when seller audits the title before contract pack is produced, and buyer should audit the title when the contract bundle is received. If there is a restriction on the title, what does the restriction say? Do I know that the restrictioner is going to be collaborative? Are there going to be, or is there any indication that there's going to be a problem? If there is going to be a problem, then I need to address it today. And again, imagine we're completing on Friday. Imagine that today I've just discovered that we're going to have a problem with regard to a restriction on the title, and we're acting for the buyer. My view would be I'm unable to complete on the basis that I'm not going to get a good and marketable title. If there is a restriction on the title that I can't comply with, I'm going to acquire an equitable interest at completion, but that equitable interest is not going to be transferred into a legal interest until registration is completed, and a restriction that can't be complied with is going to block that registration process. So if there is a restriction, is the restrictioner going to be compliant and assist us with regard to removal? If not, are we comfortable with disapplication, cancellation, or modification? Again, I would have to say, if we discover this is a problem today, it's going to be too late to complete on Friday. The likelihood is that we're going to have to put back completion and either establish some form of line of communication with the restrictioner or make application to disapply the restriction. That's not going to be a really quick fix, to be honest with you. Disapplication applications to the land registry can take anywhere sort of up to 2 or 3 months. Average length of time seems to be a month to 6 weeks. If you are thinking about disapplication, provide the land registry with as much information as is possible as to the steps or measures that you've taken to comply with the restriction, and explain to the land registry carefully what the issue is. And of course, ask for the application to be expedited, given the fact that you're contractually obliged to complete on Friday, and the restriction is likely to prevent completion taking place. So the other point that I want to note here with regard to use of restrictions is the use of Form A restrictions. And again, I've just had this very scenario put to me recently. What is the position where a tenant in common dies? Well, a Form A restriction isn't going to protect the executors or personal representatives of the deceased tenant in common. You've got to use a Form N or Form Q restriction to protect the position. So if we've got a deceased tenant in common and we're due to complete on Friday, what is the position with regard to the tenancy in common? Can the seller appoint another trustee, and can that other trustee execute the transfer to facilitate completion? These are the issues that again need to be carefully considered. Where we have a deceased tenant in common and we're aware of that when we enter into negotiations in connection with the purchase, then this issue can be easily resolved. Where we have a tenant in common that dies between exchange and completion or just before completion, the appointment of a second trustee shouldn't be that much of an issue. Normally, the solicitor acting for the seller will agree to be appointed as trustee to enable the sale to proceed. But be careful, again, with that point. Moving on, if I can, double L restrictions. If there's a double L restriction on the title, this is an attempt by the seller to eliminate the risk of property fraud. It requires the conveyancer to verify the client identity. Now, there's been some confusion about this. Is it necessary for the conveyancer that lodged the double L restriction in the first place to verify client identity, or is it the responsibility and task of the solicitor or conveyancer acting on the current sale? The latter is in fact the position, and that should not be a problem or an issue for the seller's conveyancer or solicitor to verify identity and to comply with the double L restriction. There is a point about double L restrictions, and again, just for completeness, a lot of firms don't like the use of double L restrictions because this requires the seller's solicitor to undertake an action or activity that generates risk for them with regard to their verification being incorrect and the seller in fact being a fraudster. In those circumstances where the conveyancer for the seller has verified their identity to comply with the double L restriction, the view is, and there's no case law on this as yet, that the seller's solicitor is going to be in the firing line with regard to a negligence claim. Again, check addresses for service with regard to double L restrictions on a registered title. From a fraud perspective, is the address for service that originated when the purchaser purchased the property the same address for service as revealed in the proprietorship register? And again, check addresses, etc., in the double L restriction to make sure everything seems in order. I've talked about disapplication of restriction, and again, Practice Guide 19 was amended in November last year to highlight the use of disapplication, which is a temporary measure enabling our completion on Friday to take place. So in an ideal world where we've got a restriction that we can't comply with, we've spotted it early, the seller's made application for disapplication for us during the conveyancing process. We've now got disapplication and notice of disapplication on the title, enable us to complete on Friday and to register our client as registered proprietor. Modification and cancellation of restrictions are far more difficult to achieve. The Land Registry will, in all likelihood, undertake their own investigations to see what the position is relating to the restrictioner and to see why the restriction is currently blocking the title. So modification and cancellation is not going to be a quick fix if we're due to complete imminently. Disapplication isn't going to be a quick fix, but it's going to be quicker than modification or cancellation. Remember, Section 77 of the Land Registration Act 2002 can be used as quite a weapon to discourage anyone putting a notice or restriction on a title who shouldn't do so, or to enable the applicant who has lodged the notice or restriction on the title to assist with regard to removal or cancellation before completion. It's often a very useful lever if we're panicking about completing on Friday and we've got someone that's lodged a notice on or restriction on a title and shouldn't have done so. the threat of claiming damages against them under Section 77 will often encourage them to assist with regard to cancellation of the notice or restriction, whichever is the case. Section 77 is available to the registered proprietor, but also to any other interested party. So potentially you could have both seller and buyer talking to the applicant who's lodged a notice or a restriction on a registered title, inviting them to remove it immediately, and otherwise a claim for Section 77 would be made by both for loss that they sustain as a consequence of an inability to complete, as a consequence of the notice or restriction on the title, acting as a sort of barrier to completion. With unregistered land, again, just do an audit of the title, just have a look at it and make sure that from the seller's perspective, all the deeds that were copied in the epitome are now available, to make sure that where documents need to be retained on a sale of part, that we're providing the buyer with some form of confirmation relating to undertakings for production of documentation if necessary. Make sure that the root of title and the chain of ownership from the root is in order. If we need to retain copies of documents, let's make sure that we retain them. Interesting and important point. If title deeds are lost in transmission from seller to buyer after completion, the risk with regard to their loss vests in the buyer. In other words, if the deeds and documents go missing via the post or DX system, it's the buyer's responsibility to try and perfect the title or to try and do something to provide the land registry with evidence of ownership. Might therefore be sensible for the seller to take copies of all the documents at completion and to retain them, just in case the documents are lost, or to make sure that their transmission from seller to buyer is using the safest possible platform for transmission. If they're lost, it is the buyer's problem relating to either completing the title, producing certified copy documents, etc., etc. And that can be a really big problem at the moment. In the good old days, where deeds and documents were lost, the land registry were pretty relaxed. In 2024, they are far from relaxed, if that is the position. They may be willing to accept certified copy documents, but they may not. They may simply say, well, all the buyer is entitled to is some form of possessory title, with all the problems that that generates. Remember that where there are problems with regard to an unregistered title, the expectation is that the title will be dealt with and resolved during due diligence and not at this late stage. Interesting point with regard to registered and unregistered land. I had the fortune last week of doing some training with Freddie from Stewart Title and Robert Kelly from Stewart Title, and both of them made the same point about the fact that title indemnity insurers generally, Stewart Title in particular, are geared up to producing defective title insurance policies right at the last minute. And it is even possible for title indemnity insurance to be backdated in certain circumstances. So where we are encountering a problem with regard to a registered title or indeed unregistered title, and it is possible for the problem or the issue to be plugged courtesy of defective title insurance policy, then do be aware that Stewart Title, Freddie, Robert, Teddy and the colleagues can assist you with regard to the production of a title indemnity policy very swiftly. So again, if there's an issue, hopefully it's being dealt with in a timely manner during the due diligence process. We're now right at the 11th hour before completion. We can still take out title indemnity insurance. Again, having had the fortune of listening to Robert and to Freddie last week, they maintain the view that I do, that the buyer should be always taking out the policy, but the seller should be paying the premium, or there should be a deduction in price to cover the cost of the premium. The reason for that is that it is the buyer that needs the policy. Let's have a look at things from the buyer's perspective now. And as far as searches are concerned, what could happen relating to searches that could cause us a problem? Well, our land registry search might reveal adverse entries, or might reveal that another land registry search has been undertaken, in which case someone else has an interest in the land potentially. Important that where we get a land registry search, we check it out If there are adverse entries, we see what the adverse entry relates to, and where appropriate, we communicate with the seller immediately that there is a problem and ask the seller whether the problem is capable of resolution before we're due to complete. As far as a land charges search is concerned, make sure that if we are undertaking a search against the seller, we search against the correct name for the correct period of ownership. Where there's confusion as to the spelling of the seller's surname, so in different deeds and documents we have Mr. Smith spelt with an I or a Y or an E on the end or whatever it is, we search against all the names, all the conceivable names. With land registry search and land charges searches, we want the search result back. We want to look at the search result and check on our case management system or on our paper file that everything is in order. Same issue with regard to bankruptcy search against our buyers' names on behalf of lender. I'm often asked about company searches, and firms will say to me, well, if the land is registered, there's no need to do a company search where the seller is a limited company. I would disagree with that, and I'd always do a company search against the seller limited company, just to check their status, just to see if there are any floating charges or any references to any form of voluntary arrangement, CVA, that the company has undertaken. And if there are adverse entries with regard to searches, the general proposition is it's going to be for the seller to resolve the position or to provide you with satisfactory evidence that the matter has been resolved, except for the bankruptcy search. I mentioned on the slide here a point that's often overlooked with regard to preparation for completion, namely the need for client inspection. We've discussed, haven't we already, the need for client inspection as part of the buyer's due diligence. We've also explored briefly the need for the buyer to inspect at exchange of contract in certain circumstances. I'm now mentioning to you 2 points where we're concerned about the honesty or otherwise of a seller, or where we've got, as I mentioned earlier, third parties in occupation who have promised to vacate at completion. In order to alleviate or mitigate against heartache on the day of completion, it might be appropriate for the buyer to be told to go round to the property the day before just to check that everything seems to be in order. In other words, that the seller is packed and the premises appear to be in a state of flux, in readiness for tomorrow morning, and that if someone is in occupation, they're there, but volunteering that they're happy and will in fact be vacating the property as they're contractually obliged to do in the morning. Not necessary in all cases, but I would just say to a buyer, look, it's worth just going around just to check, to make sure everything's okay, to confirm arrangements with keys, etc., so that there aren't any nasty surprises on the morning of completion. The client should also be told of their duty to inspect at completion. This arises from the Land Registration Act 2002 and Land Registration Rules 2003. The client buyer, when they are submitting an application to register themselves as proprietor, are under a duty to disclose to the Land Registry any overriding interest that exists at the point of completion. That's the purpose sitting behind Land Registry Form DI, which I'm sure you've seen, but my guess is you'll have rarely encountered, and certainly even more rarely filled in on behalf of the client. The idea is that at completion, if there are any overriding interests that exist, the buyer is obliged to disclose them to the Land Registry in Form DI. The reason then is that the buyer will, having notified the Land Registry, trigger the registration of a notice on the title to protect the overriding interest, which then loses its overriding status. So client inspection important before completion from a practical perspective, make sure everything's in order to ready to complete, and required on the day of completion to fulfill their obligation to the Land Registry. Again, if the client inspects on the morning of completion and there are issues with regard to state and condition of the property, with regard to items being left that shouldn't be left and items removed that should have been left, etc., again, a practical point, explain to the client the need to take photographs to have evidence as to state and condition or items removed, etc., for later use in the event of dispute resolution. So we're prepared for completion. We're now perhaps on Thursday when we're due to complete tomorrow. Where I am giving undertakings to the buyer's solicitors on the day of completion, I like those undertakings to have been prepared the day before. Where someone's signature is required to the undertaking, the likelihood is that they're going to be in a calmer frame of mind and are going to be available to help me execute or sign the undertakings where I'm unable to sign them as a sort of trainee or paralegal, etc. And the firm should have standard sets of undertakings that are given in the conveyancing process, and these standard forms of undertaking should be utilised on all occasions. Where an undertaking is bespoke or prepared on off the hoof, as it were, I'd want to be very, very careful. And if such an undertaking is required, I'd probably want a sort of collegiate approach with other members of the team, rather than me just sort of agreeing with the other side the form of undertaking that should be given. Other issues with regard to preparation, look at the TA13 and just remind ourselves what we're doing when we're acting for the seller. Which charges are we redeeming? Which notices are we extracting or terminating? What payments are due out? Is everything in order? And am I happy to proceed? Again, from a buyer's perspective, have I audited my searches? Have I clarified that all the searches are clear and clean? And do I have the appropriate funds in place to facilitate completion tomorrow? Again, where I've got a dependent sale on a purchase, I'm going to check everything is well with regard to that transaction. Giving yourself time to do this the day before completion, giving yourself time to draft everything that needs to be drafted and get everything in order, will save you a lot of heartache, a lot of potential problems on the morning of completion. Generally speaking, I say to conveyancers, Friday, when we're actually completing transactions, we should be just focusing on the mechanics of completing and the administration associated with it. The moment we've got a file where there's a problem, or heaven forbid, more than one file when there's a problem, we're going to increase stress levels, we're going to increase risk and vulnerability for claims. So anything that we can do to prevent that has got to be good news. What's the latest time for completion? How much am I required to send to the other side? Can I notify my accounts team of everything so I don't have to deal with those things in the morning, so we can just get everything lined up in readiness for green for go on the Friday morning of our completion day? Again, important to keep client aware of any issues or problems. As we'll see in a moment or two, if we have a hiccup or a problem relating to completion, it is absolutely essential before we do anything, we make the client aware of the problem and advise clients as to choices they've got, rather than simply diving in and serving a notice to complete, or ignoring the other side and going to periscope depth. Talking to someone about this last week, where they'd served a notice to complete without authority from the client, quite simply because they were so fed up with the buyer's solicitors not communicating about what was going wrong. And again, in those circumstances, it may be perfectly right and proper to serve a notice to complete, but you need your client's authority and instruction to do so. Again, we've talked about, from the seller's perspective, the day before, just having a look at redemption figures and preparations to redeem. Again, we might be talking to our accounts team so that the monies are ready to go. We'll give a quick check over the TA13 form just to see if we've missed anything. Again, we're likely to be subject to an obligation to comply with the Law Society's Code for completion by post. Are we ready and available to do that? We've talked about preparing for completion from the buyer's perspective. Again, getting things ready the day before makes life an awful lot easier for everyone concerned. Law Society Code for completion by post. So let's now move ourselves to Friday morning. Okay, and let's assume we're acting for a buyer. We're going to place the purchase price into this banking system for transmission from our client account to the seller's solicitor's client account. We are obliged to notify the seller that the funds are now on their way. I would do that by email. As far as the code is concerned, it then requires the seller's solicitor or conveyancer to notify us that funds have been received, and then it's for the seller to complete the transaction. This will involve the seller dating the transfer and the seller providing us with the appropriate undertakings as per the TA13. Interesting point, it is only the seller theoretically that needs to sign the transfer. The buyer would only be required to sign the transfer where the buyer is entering into an indemnity covenant with the seller. However, I would like my buyer client to sign the contract before completion, so that when it comes back to me from the seller at completion, I've got the transfer executed by all the parties, dated by the seller's solicitor on the day of completion, and that goes ready to go off to the land registry with my electronic application to register, or my paper application to register my client as proprietor. Important point, when you're acting for the buyer and they're executing the transfer, whether it's pre-completion or post-completion, always highlight where clients are buying as co-owners what box 10 of the transfer says. So, Mr. Client, we have discussed co-ownership and we agreed that you'd be buying as joint tenants in law and in equity. Please have a look at box 10 of the transfer. This confirms the position. The reason for that is twofold. One, it enables you to be clear that the clients remembered what was said when co-ownership was discussed all those days, weeks, or months previous. And two, you're highlighting to the client this is an important document that evidences how the beneficial interest is to be held between you and your fellow co-owners. So it's a bit of sort of belt and braces protection for you, as it were. The seller acts as the buyer's conveyancer's agent at completion, so there's an obligation to date the transfer, there's an obligation to dispatch the transfer and any other documents prescribed in TA13 to the buyer's solicitors, either by post or DX, and it's necessary for the seller's solicitors to give the appropriate undertakings as per the TA13 form. On the issue of undertakings, I was just doing some work on this last week. Where you're willing to accept an undertaking from the seller's solicitors, you should really do a risk assessment. In other words, am I comfortable with the undertaking that the seller's solicitors provide? Do I trust the seller's solicitors? And again, someone raised the point last week. What is the position if the seller's solicitors are discharging a charge and the value of that charge exceeds the firm's professional indemnity cover? Well, in those circumstances, I'd be conscious of potential risk, and I'd want a solicitor and partner in the seller's firm to sign the undertaking. And again, if I was really concerned about the status of the seller's solicitor or conveyancer, I might want to actually redeem the charge myself by dispatching the monies required to redeem direct to the lender. The reason I'm worried about is that, let's assume our client is selling a property for £11 million. There's £8.5 million in favour of Barclays Bank as a first charge. If I rely on a seller's undertaking to discharge that charge and they are unable to comply with it, then that would constitute professional misconduct. It would also constitute a potential claim against the seller's solicitors for breach of contract and breach of undertaking. As a consequence of that, where the seller can't complete, and I'm claiming on their indemnity policy, if they have indemnity cover for £3 million, the actual charge is £9 million, then potentially I'm not going to be able to recover all my client's loss from the insurer. And again, caution needs to be exercised. With regard to undertakings, as I say, a simple undertaking to dispatch documentation to me, etc., I'm not going to be too pedantic about, but where there's an undertaking to discharge a charge, I'm going to do a risk assessment to ensure that I'm comfortable that the undertaking that's being given to me in the event of default isn't going to generate a nightmare position for my buyer client. It will generate a difficult position, but where we've got sufficient indemnity cover sitting behind the seller, the matter will be capable of resolution at some point in the future. Where, however, the amount required to deem the charge exceeds that amount, then the issue of indemnity cover is only part comfort for the buyer. Next thing I want to talk about is the early completion procedure. Very, very rare application. But you could have a situation where the early completion process applies, in which case what happens is this. The buyer is immediately registered as proprietor on the day of completion, and the buyer's charge is registered as a first charge, but the seller's charge, which has not as yet been discharged, and the land registry has not as yet received evidence of discharge, that charge remains on the title pending redemption, and evidence of redemption being provided to the buyer's solicitors. So do watch out for the early completion process. If the seller has an institutional mortgage on the title, the early completion procedure will not apply because of the seller's restriction, sorry, seller's lender's restriction, and the early completion procedure is fortunately rarely encountered. Where it is encountered, indemnity insurers are worried that we've completed, the buyer has a first charge on the title, but the seller's charge is now a second charge on the title. And what is the position if everyone forgets about that charge, or there's insufficient monies for that charge to be discharged at some point in the future? So again, just a heads up about something that is highly unlikely to arise, but could arise. So let's think about some things to consider during the completion process. What happens if we're now in Friday and we're due to complete and there's a problem? The problem will normally manifest itself in two ways. Either the other side are going to be straight on to us to say, look, we've got a problem here. Our funds haven't arrived. There's an issue with our dependent sale. I don't know. Searches aren't in. Searches are in that reveal adverse entries, whatever it might be. In which case, consider the position. And what I always say is, look, is what I'm told likely to mean there's going to be a delay, but we're going to complete? Or is what I'm told going to mean this transaction is going to die a death? Where there's going to be a delay and all things being equal, will be completing on Monday or Tuesday of the following week, then that's fine. We can claim contractual interest, advise our client as to the current position, explain what's likely to happen. And yes, there's a bit of inconvenience, but we know the transaction is going to proceed. If, on the other hand, we've got a fatality with regard to our transaction, then what we have to do is look at our client's position. So let's assume we're a seller. Buyer has told us about a problem that means this transaction isn't going to complete. We've got to tell our client about their obligation to mitigate loss. If we've got a dependent purchase, that might mean taking out some form of bridging finance, recovering the cost of bridging from the buyer who's been unable to proceed. It may be that we're going to have to lose our potential purchase and be liable for loss with regard to that breach of contract. We might be in a position that we can do something that enables transactions to proceed, notwithstanding the buyer's predicament. We need to advise client then as to the choices that are available to them. We should always advise a client where we've got buyer default that we could serve a notice to complete, but the client needs to understand the double-edged sword that a notice to complete is, in that the buyer is then given a 10-day working day period to get their act together, and during that time the buyer is still entitled to complete provided they pay contractual interest. Or the other problem with regard to a notice to complete is during that 10-day period when completion takes place, whether completion takes place is outside our hands. We could, as an alternative, issue proceedings for specific performance to try and compel the buyer to complete. That would be a dangerous course of action because specific performance is an equitable remedy, therefore no guarantee that it will be awarded. And for a specific performance, a court is not going to compel a buyer to complete a transaction when the buyer does not have funds to do so. The client should have the position explained to them. If you have a property litigation team, talk to a property litigator about choices. If you don't have a litigator, then talk to a member of council who might be able to provide you with some sort of informal assistance or guidance before formally being instructed. If you have a situation where the buyer, that's the defaulting party, goes to periscope depth and just says nothing, about what the problem is, then you've got a real dilemma on your hands because you don't know what the issue is. If you have a situation where we've tried to contact you all day and have heard nothing from the buyer's solicitor, then I would be tempted to think this is going to be a fundamental breakdown. We're not going to be able to complete at all. Normally, the other side will contact you and tell you that there is a problem, but the problem is temporary. I tend to find in my experience when the buyer's solicitors or conveyancer just goes completely off the map, there's a fundamental problem. But it's our task to try and extract as much information as we can from the buyer or the estate agent or whoever to tell us what the problem is and then to decide. As far as the mechanics of completion are concerned, I've explained it. It's relatively straightforward. Where a buyer or seller cannot complete or will not complete, then we have a potential action for breach of contract against them. Again, client told about the potential to bring a claim and also importantly about their obligation to mitigate loss. Someone sent me an email about mitigation of loss on Friday, and the point is that no matter what, the seller client, assuming the seller client is the innocent party, is under an obligation to mitigate loss. Should a notice to complete be served? Well, if the seller in our example is able to complete, if it is to the seller's advantage to serve a notice to complete, if the transaction is fatal and fundamentally flawed, then yeah, a notice to complete should be served. A notice to complete can only be served if the seller themselves is ready, willing, and able to complete themselves, and having taken instruction from the client, it is in the client's best interest to do so. There may be circumstances where it's not in the seller's best interest to serve a notice to complete, but the position should be investigated and the client have the position explained to them. What does the notice to complete do? It makes time of the essence, meaning that the other side has 10 working days to actually either complete or alternatively, after the expiry of the 10 working day period, the innocent party is then entitled to sue for breach of contract. If suing for breach of contract, the seller, in our example, would sue for contractual interest that's been and it's entitled to as per the contract, or actual loss that the seller has sustained as a consequence of the breach. The seller would then, in the circumstance where there's a fundamental inability to complete, be required to put the property back on the market to secure a buyer and to claim from the defaulting buyer the difference between the contract price and the actual price that the property is ultimately sold to a second buyer for. If you are going to serve a notice to complete, it is best to serve it by fax. Fax now is frequently an impossible method of service, in which case you're looking at post or email. Most firms will exclude service of a notice to complete via email. On expiry of the notice to complete, the innocent party, in our example, the seller, would be able to sue for breach. You can't extend the time for completion once the notice to complete has been served. You could issue, in other words, you can't extend the time within a notice to complete. You could, however, serve a further notice to complete and withdraw the original one. It isn't possible to unilaterally withdraw a notice to complete. So, where we've got a default position, what about the deposit? Can the seller immediately retain a deposit where our buyer hasn't completed on Friday? The answer to that question is no. Under Section 49 of the Law of Property Act 1925, a court has jurisdiction to determine what is to happen to a deposit. And to be fair, in most circumstances that I've just discussed, the seller would be entitled to retain the deposit. The deposit retained would be deducted from any damages that were claimed at the end of the day, if a damages claim was to proceed. If a reduced deposit was paid by the buyer, the balance of the deposit would due to be paid where the buyer is unable to complete. If the buyer is in default, but the default is no fault of the buyer, so mortgage offer withdrawn or some other circumstances, then the court may not order that the seller can keep the deposit. There may be some form of split of the money and some money is due back to the buyer. Where a seller is ultimately able to sell the property for more than the original contract price, in other words, where the seller sustains no loss whatsoever, I have seen a situation where the court has ordered that the deposit be returned in its entirety to the buyer, but that would be unusual. If a seller is in default, then again, the seller is obliged to repay the deposit, and a buyer could sue for specific performance, in other words, to compel a seller to complete. But again, as far as specific performance is concerned, a court would be unable or unwilling to make an order that would render a seller homeless. Talked about the code for completion by post, we didn't worry about that. We talked about remedies. This section 49 of the Law Property Act 1925 is important. There is not an automatic entitlement for the seller to retain the deposit or for the deposit to be repaid to a buyer, assuming either is the innocent party in the event of an inability of the other to complete. But all things being equal, a seller that's innocent will keep the deposit and a buyer that's innocent will get his or her deposit back. There are other remedies, as I say, an action for specific performance is possible. A claim for damages is possible by the innocent party against the defaulting party. I repeat the importance of the innocent party being aware of their obligation to mitigate loss. Very, very important point that is sometimes overlooked. And again, where we're dealing with a default, I would always have a property litigator or counsel to assist my client and to give the appropriate advice. The other point with regard to remedies, where we've got a party that's in default, be aware that we should really be entering into a new retainer with the client in connection with litigation and advice ancillary to litigation over and above the conveyancing process. I know a lot of firms wouldn't charge a client for doing additional work, but it's important to appreciate that your original retainer is unlikely to extend or expand to facilitate advice, assistance and guidance with regard to breach of contract claims or other claims as a consequence of an inability of one of the parties to complete the transaction. So, to conclude today, number one, make sure you're aware of your duties with regard to the code for completion by post. When you're acting for the seller, understand and appreciate the additional burden that you're under with regard to warranting seller identity. Be aware that the completion process is only part of the story with regard to the conveyancing process. There's a lot more, particularly for a buyer, to do post-completion, and therefore simply getting a transaction over the line isn't the end of the matter. In footballing terms, I describe it as half-time. Understand and appreciate that as a consequence of that, risk assessments being undertaken with regard to funds, property fraud, etc., remain live and active throughout the transaction, particularly in connection with acting for the buyer. If we are preparing for completion, prepare at a time where we're able to devote appropriate time and attention to the matter. Try not to compress everything into a busy completion day. That's when mistakes are made and issues overlooked. Getting everything done, if possible, well before completion is good. Doing an audit before the day of completion and checking that everything is in order and everything that can be done has been done, again, is good practice. Where there is a delayed completion, ask yourself, do I trust the defaulting party's lawyers? Are they telling me the truth? Are they putting me fully in the picture? And have they done so as soon as the problem is identified or identifiable? If they haven't, then let's assume the worst. If they have, and we can trust them, then let's come up with a plan of campaign that facilitates completion to take place as soon as possible. Be careful about allowing a buyer into the property on the basis that completion is going to take place on the next working day. Always use a tenancy at will, and always warn a seller client that once a buyer is in possession, if there is a fundamental problem, meaning the buyer can't ultimately complete, ultimately we would need a court order to get the buyer out at some point in the future. So whilst it may appear to be kind and thoughtful to allow a buyer to go into possession pending completion, it could come back and bite the seller at some point in the future. Even where undertakings are provided, even where an express tenancy at will is utilised, again, at the end of the day, the buyer is in possession of a dwelling house, a court order would be required to get them out. Be careful about notices to complete. In that a notice to complete is this double-edged sword. It makes time of the essence, but imposes duties and obligations on the party that's serving the notice to complete. Those duties and obligations may be something that the seller is, being the innocent party, isn't willing to oblige themselves relating to the duties and obligations. Remember, where you're faced with a delayed completion or a completion that's gone off the rails, don't panic, don't lose your temper. Make sure you get instructions from your client. Where there are decisions to take a step back and have a think. So if you've just you come off a telephone call or you're on the phone to the other side and there's a problem, don't react. Say, hang on a minute, I need to talk to my client, I need to have a think about it, I'll come back to you in 5 minutes, rather than, right, this is what we're going to do. If nothing else, you're going to need your client's instructions, and therefore you're going to have to put the phone down or delay the response to an email and take instructions from the client. And again, if in doubt, if you've got a property litigator in your firm, talk to them or talk to counsel and see what he or she has to say about the current situation. If you're acting for the party that's in default, a good tip, again, take a step back and ask yourself, if we're going to be sued for breach of contract, has anything happened in the transaction that would generate a defense? So let's look at the TA forms and say, could there potentially be a misrepresentation claim? Has the seller done something or not done something that has led to the buyer default? So don't just hold your hands up and say, you know, this is doomsday and we've got a major problem on our hands. We probably have, but just ask yourself, is there any ammunition that I can have that can prevent the seller from taking whatever action they're intending to take or they could take? Or do I have a potential defense to proceedings if proceedings are brought? On that happy note, ladies and gentlemen, that concludes my presentation. So what I'm going to do now is have a look at the chat and see if there are any questions or queries.
I think there's one from Leah Wilman.
All right, thank you.
Question for Ian. My client bought a flat 18 months ago. The contract required the seller to enter into a deed of variation for the lease prior to completion, but the seller's solicitors did not make sure that they had the deed in time. It turned out that the deed had not been approved by the freeholder, even though the managing agent had been given the impression that it had been. The deed has since been agreed with the freeholder, although not in the form agreed before exchange, but 7 months on, is yet to be signed by them. Land registry application held up as a result. Can my client sue the seller after all this time?
Yes, well, the answer to the question, Freddie, is an emphatic yes. The issue is, what loss has the client sustained? So additional legal fees, any sort of additional land registry fees or penalties, all would be recoverable in those circumstances, depending on what the special condition the contract said in connection with the deed of variation. But to answer the question, yes, that would be actionable. I'd be interested to see the wording in the contract. If the delegate would like to drop me an email, Freddie, with detail as to that wording, but the answer would be an emphatic yes. An important point, Freddie, arising from that, we're conveyancers, we're transactional property lawyers, we're not litigators, okay? So it's all well and good saying, yes, we can sue for breach of contract, and in the context of what I've been told, I think you could, but I'd always want a property litigator to have a look at it and say, yes, we can sue for breach of contract, and yes, these are the sorts of damages that are recoverable. Often what you'll find, particularly with a conveyancing transaction, there will be a party that's in breach, but the potential costs associated with bringing proceedings far outweigh the damages that could be recovered, and therefore you say to yourself, it's not economic to pursue this claim. But a client in that situation may be able to bring a claim in the small claims court for the loss that arises from breach. That might be the way to go forward in circumstances where the claim is not of particularly high value. But great question. Thank you for that, Freddie. Any other questions?
I think that might be everything.
All right. Well, if there are any questions, Freddie, then you know, what we can do, I'll just show you another slide. You can raise questions via that email address, info@IQ Legal Training. So I'm just going to have a look and see if there are any more, but I don't think there is anything. No, nothing in my Q&A box, nothing in the chat. So Freddie, all I'd like to do is to thank you once again on behalf of Stewart Title for organising today and for assisting, sitting in the background. There are notes and slides that accompany the presentation that will be sent out to people that have attended. Do speak to Freddie, Ted, Robert, Stephen about any requirements for title indemnity insurance and any questions or queries arising from anything that I've said today, or indeed if you have questions or queries about conveyancing generally, drop me a note by email. Two other things that I think are important: we organise residential conveyancing forums on a monthly basis, which Stewart Title sponsor. Come along to those, they're really interesting, really informative, and we'll deal with any questions or queries that anyone has about anything to do with resi conveyancing. We get big audiences that attend, and it's amazing how willing conveyancers are to help one another with regard to problems or issues they're encountering. On that happy note, Freddie, thank you very much. Thank you everyone for attending today. Thank you for coming along to this series. It has been really popular. If you would like training on any specific topics, then I'm sure that Stewart Title will look and listen and perhaps be prepared to sponsor future events relating to any new topics or any new issues that you're encountering. But on that happy note, thank you very much for coming along today. Freddie, as ever, pleasure speaking to you and listening to you, and thank you for coming along. Stay safe, everyone, and speak soon.
Thank you to you, Ian. Bye-bye.